Professor Michael A. Olivas, who will deliver this year's Victor S. Johnson Lecture. The topic of the lecture is Professor Olivas' book entitled Colored Men and Hombres Aquí, and time permitting, he will take questions following the formal remarks. Today's lecture is made possible by Tori Johnson, a graduate of Hamilton College and Vanderbilt Law School. Tori has been the District Attorney of Metropolitan Nashville-Davidson County for more than 2 decades. I have to change that. It's going to be 3. It's crazy. Throughout his career, he has been a devoted public servant, and he has played a significant role in the life of Vanderbilt Law School and its students. Please thank me in joining Tori, both for his commitment to the law school and for making this lecture possible. Now, our lecturer, Michael Olivas, is the William B. Bates Distinguished Chair of Law and the Director of the Institute of Higher Education, Law and Governance at the University of Houston Law Center. He has also served as the Chair of the UH Graduate Program in Higher Education, as well as the Associate Dean of the Law Center twice. He has been a visiting professor at the University of Wisconsin Law School and the University of Illinois College of Law. He is the co-author or author of 14 books, and we are honored to hear him speak about one of those books today. He holds a BA magna cum laude from Pontifical College Josephinum, an MA and PhD from The Ohio State University, and a JD from Georgetown University Law Center. Now from his resume to his book. The book concerns Hernandez versus Texas, a landmark civil rights decision in which the U.S. Supreme Court held that Mexican Americans were a discrete group under the Equal Protection Clause of the 14th Amendment. Now, Hernandez versus Texas was a landmark civil rights decision in another sense because it was the first U.S. Supreme Court case argued by Mexican American attorneys. In his book, Professor Olivas provides both context and content for this incredible historic moment and the brilliant lawyering behind it. He draws together original source materials, trial briefs, and more, showing in his publisher's words that it is possible to tilt against windmills and slay the dragon. Without further ado, I am pleased to introduce Professor Olivas.
Thank you very much for the generous introduction. My students can never believe that anybody would actually come hear me if they didn't have to, so I'm all the more grateful for the students who are here today. I dedicate this talk today to a friend of many years and a Josephinum Seminary classmate, a member of your own divinity faculty, Professor Fernando Segovia, who's here today. And when I was growing up in the Catholic seminary, and I studied to be a priest for eight years, high school and college, I was from the last generation where kids went straight from high school all the way through. In fact, I was the last class. They began closing the seminary every year that I completed. I took it personally for many years, not realizing the demographics of this. I will say that studying to be a priest for 8 years has come in handy when you practice law in Texas, because I believe in deathbed confessions, I believe that people can be saved, and I believe that you ought to be judged by your hard works, and certainly this particular case is an example of all of those. It is a landmark case, but you wouldn't know it. Truth is that most criminal law and criminal procedure case books don't teach it. Most faculty don't know it, and I confess that I didn't know it for many years. In fact, I came to even know the case by a complete fluke when a friend of mine asked me if I knew Judge De Onda, and I said, yes, he's a good friend. He said, well, is he the Judge De Onda? I said, well, he's a Judge De Onda. I don't know. So, he argued a Supreme Court case. And I said, well, really? And so I went and asked him. And, of course, he acknowledged that he had. He was so modest that he had never said this. In fact, I spoke at his funeral 2 years after 2 weeks after this book was published, and his sister came up and she says, Michael, that was just lovely. I didn't know Jimmy had argued a case in the U.S. Supreme Court. His own sister, and he wasn't estranged, he had never talked about it. In fact, his participation in the conference that I held that led to this book was the first time he'd ever spoken publicly of it, for reasons that I hope will become clear. He also, I gave him a copy of the book. I sent it to him. He had a summer home in Michigan, and his wife called me and said that he was dying, and I had to come up there to kiss him goodbye, and so I did. And I came in that night, and the book was on his chest, and he'd fallen asleep. And I said, "Oh, he fell asleep." She says, "Well, yeah, Michael, he's been trying for a week to read it, and he keeps falling asleep." And I said, "Well, and so I mentioned this at his funeral also, and I said, this book is a testimony to my life. People fall asleep on my work, and then they die." And his wife laughed. She says, "You're the only person that could have made me laugh about this, but you did." And therein lies a very unusual tale. In October of 1951, my first October in the world, I was born in February of 1951, in a cantina in Edna, Texas, a town halfway between Houston and San Antonio, there was a bar fight and a killing in a cantina. This is so extraordinary and unusual fact pattern. I think it only happened 24 times in Houston last weekend. But the unusual thing about this case was that it led to the U.S. Supreme Court. And this particular tale is unusual, particularly for the courage of the lawyers and, in some respects, of the defendant. In this particular case, Pete Pedro Hernandez, a man who was born with a club foot and who had a terrible temper and drank too much. Imagine that, an argument fueled by liquor. Never happened before, never happened since. He shot Joe Espinosa in a tavern in front of 30 or 40 witnesses. There was never any question as to that. And within 2 weeks, he'd been sentenced to life imprisonment. It was his good fortune that he shot a Mexican, because at that time, no one who'd ever shot a Mexican American in the state of Texas had ever been put on death row. The opposite, mind you, happened regularly. That is, any black or Mexican shooting a white would surely lead to the death penalty in those days, and often today as well. But in this particular case, Pete had a trial and 3 days later was sentenced for life. But the case doesn't really start there. The case starts with the Aniceto Sanchez case, a case that happened 18 months earlier. And this case happened to be Judge Lee Onda's, then lawyer Lee Onda's, very first murder trial. He had apprenticed himself to another lawyer in Houston, Johnny Herrera, who had, by my count, over 400 cases, both civil and criminal cases. He was the only Mexican-American lawyer, that is the only Spanish-speaking lawyer, between Galveston on the coast and San Antonio, which even today is going to be a 5-hour trip. All that way, he was the only one that practiced criminal law. There were 3 others in the Houston area, but they all had civil or family practices. And for the most part, he once said he was paid in chickens. That is, his people would pay him food or services, and so he had the best manicured lawn in all of Houston. But he never made any money at it, even with those 400 cases. Well, he had graduated from what is now South Texas College of Law, then the only law school in Houston. And this was before Sweat v. Painter, which led the Texas Southern Law School for Negroes in Austin to be moved to Houston. And then beginning in 1947, the University of Houston, where I've taught since 1982. The Aniceto Sanchez case occurred in Sugar Land, Texas. And most people have heard of Sugar Land, Texas because of the Steven Spielberg movie, his second feature film starring Goldie Hawn, who runs off in a car chase scene to Sugar Land, Texas. Sugar Land, Texas was in suburban Houston, and in 1950, it had the country's largest prison, half black and half Mexican, all of whom were dispatched to work for the sugar cane companies that dotted the area. Sugar Land was because there was so much sugar being harvested there with help from the inmates. It was just closed 2 weeks ago, in fact, after all this town, and it is the place where, I want to say Robert Johnson, I don't think it was Robert Johnson, whoever it was that did the Midnight Special was in that prison when he heard the Midnight Special train going by. So it's a very well-known place in sort of criminal folklore, let's put it that way. And And Aniceto Sanchez, also fueled by alcohol, shot a neighbor who lived in the Mexican barrios. And he was tried in front of an all-white jury in Sugar Land, which was a town with about 17% Mexican Americans. You'd think just the sheer statistical likelihood of having someone on a jury, a 7-member jury, would bring a Mexican. It turned out that of the over 12,000 jurors who had been called in that county, not one was Mexican, ever. And that's both petit juries as well as grand juries as well as all the special juries. And Jimmy had just been sworn in, and he asked Johnny, how come there are no Mexicans on the jury? Shouldn't we have some Mexicans? He says, Jimmy, I have tried thousands of cases, and I've never had a Mexican on a jury. And he asked that Robert Kennedy-like question, why not, and started doing research, and that's when he discovered this. And so they actually put in an appeal saying that wasn't a jury of his peers. And they cited, for the most part, the Scottsboro cases having to do with black jurors and murder trials. But in Texas, of course, it was like the United States still today in many respects, was a binary world. Either you were white or you were black. And so Rice University, which was established without tuition for the free white inhabitants of Houston, had some Japanese students that they dubbed honorary whites so that they could attend. And so there were other examples of non-whites who were treated as if they were white, usually for good purposes. But with regard to Mexicans were treated legally white for purposes of excluding them. This town of Edna, Texas, as an example, had a sign on the restaurant window from the Texas Restaurant Association that said, "No Mexicanos ni perros," no Mexicans or dogs allowed. It had one theater, and Mexicans and blacks would go to the 5 o'clock show and then clean the place in time for the Anglos to come in after dark during the prime time of the movies. The Mexican schools went up to 6th grade. In fact, one of the mothers was put on the stand during this trial, and she said, they said, why do your children only go to 6th grade? She says, well, they won't let them in school beyond that. Well, why'd you put your children there? She said, well, I moved my other kids to another county, an adjacent county, because I wanted them to go to school further, and they assumed that our children only spoke Spanish. He said, well, do your children speak Spanish? She says, no, we wanted them to get by and to do well, so we only taught them English. And so the formal structures, while de facto rather than de jure, eerily resembled the treatment of blacks. There's a long history of lynching and the Texas Rangers. The corrido, the song commemorating Gregorio Cortez, was always that Texas Rangers had Mexican blood on their boots. And so there was a long-standing pattern of subordination in the state with regard to Mexicans. And as I said, both in Sugar Land and then in the later case in Edna, no Mexicans had ever served on the jury. In Edna, there had been over 6,000 jurors called, and not one was Mexican, in a town that was 15% Mexican-American. So again, just the sheer likelihood of having at least one. And you have to ask yourself how hard it is to get people to serve on juries, particularly when you're ruling out 1/6 of the population every single time. But in Aniceto Sanchez, they appealed in the Texas Supreme Court for Criminal Law, which is the Texas Court of Criminal Appeals. It's a bifurcated system. Said that the Alabama v. Norris case didn't count because it didn't have to do with blacks, only Mexicans. And so Aniceto Sanchez did his time. But they perfected the appeal, and when this next case came up, the Hernandez case, Pedro Hernandez, they decided to appeal and to preserve the record. And so they went in and they did some statistical analysis. They actually went back and looked at all the records. And it was James Lee Onda, the new kid, who was the lawyer who did all the work here and wrote the original brief that they used by freshening up the Aniceto Sanchez brief in this later case, the case of Peter Hernandez versus Texas. They convicted him, and they took a break during the pendency of the trial. And they decided to go to the men were going to go to the bathroom next door to the courthouse, to the courtroom. And the only Mexican in evidence there was a janitor, and he said, that was, they couldn't go there. And so they thought it was broken. They said, well, where can we go? He goes, hasta pa acá, out back there. And they go to the basement where there is a bathroom with a bathroom sign on it that says, colored men, hombres aquí. Men here. It's a sign that you'd find on a bathroom set aside for blacks and Mexicans. So, mind you, the irony of, in the same courthouse, but with public funds, in a county where the jurisdiction included approximately 16% Mexican Americans, and where the state was arguing that Mexicans were white legally, they had segregated bathrooms. And the judge acted as if he didn't believe it. He called a break. They came back in and put Judge Lee Onda on the stand, and they got this into the record that there was a separate bathroom. The judge said, there's no bathroom down there. So he stops it, and he goes down and looks, and sure enough, convinces himself that there was, in fact, a bathroom there that had this signage. And so he allowed more discovery, including this No Mexicanos ni Pharaoh sign. He brought in a local barber who said, do you know any Mexicans? He said, well, sure, I know Jose, the janitor. He says, have you ever cut a Mexican's hair? He says, not on your life. They apparently hadn't coached him very well on the proper response. And so they build up the record, and again it goes to the Court of Criminal Appeals, and again it's denied, and he's given a life sentence. Well, this time they preserved the record and decided to do what no other group of Mexican-American lawyers had ever done, which was appeal to the U.S. Supreme Court. Now, this was a much bigger thing than even today. And let me just say, when I go to D.C. with my family, I point out that if I had a client, and if I were a good enough lawyer, I could try a case in front of the Supreme Court. Not like Jimmy Lee Onda, who never bothered to tell his sister out of modesty that he had argued a case there. But they had brought into the case two other lawyers who have some significance in this matter. One's name was Gus Garcia, and the other was Carlos Cadena. Now, Carlos Cadena is a particular hero of mine because he is the first Mexican-American law professor. He taught at St. Mary's from 1952 on, and later became city attorney and argued another case in front of the U.S. Supreme Court later on behalf of the city. Gus Garcia is one of these tragic comic figures who had been a classmate, believe it or not, of John Connally at the University of Texas Law School, where he had passed in part because he was light-skinned. Carlos Cadena, at the time he graduated, had the highest grade point average of any UT law student graduate, and he held that record for another 40 years. I was later told by a subsequent lawyer, a dean of the UT Law School, that his record had been beaten. He was also on Law Review and a brilliant student, and he later became a very well-known appellate judge. And we gave him an award one time from the Hispanic National Bar, and he started crying. He says, I loved being a professor. He said, I loved being a judge, but I particularly loved being a professor. I was never overruled when I was a professor. That shows how long ago he was teaching, let me just say for the record. But he said, I couldn't afford to feed my family. And I thought that was really sad, that he would become a state appellate court judge because he couldn't afford to be a law professor with a family. It was, that's a really sad commentary on the employment of law professors, let's face it. Well, so, is there a bad connection here? That was really, that killed in front of the judges, let me just say. Yeah. Johnny Odetta, the counsel of record, as I say, had been a criminal lawyer who later became the president of LULAC, and then James Lee Onda tried this case and then went to Corpus Christi, where they ran him out on a rail 5 years later after he brought suits against the city and so forth, a different story for a different day. But in this particular case, Justice Warren, I believe, was looking for some expiation in his life. He had just been named Chief Justice. He alone on the Supreme Court had experience with Mexican Americans. Tom Clark was from Texas, but he hadn't lived in Texas for years. His son Ramsey Clark never lived really in Texas. They were Texans in the technical sense of the statutory appointment, but they weren't really of Texas. Whereas previous Governor Warren had been Attorney General who had argued a case in the Sleepy Lagoon case. He had interned Japanese as governor in Texas, in California, and and who knew Mexican Americans in the political sense. And I think that he was looking for cases to be a companion to Brown, because as you recall, one of the justices dies and they re-argue Brown, and that's the first case the major case that comes before the court. And within days of it, the Mexican American group had argued its case. It had accepted cert, had tamale sales, and raised money. I still run into people who were active in raising the money for that. And they took the case, and as I say, within days of the re-argument of Brown, argued this particular case. And during the same term, that is, between January, when the cases were heard, and May, the justices were deciding these cases, both cases. Now, you wouldn't know it from reading any of the histories, fairly extensive histories of Brown versus Board. If you read the magnificent Tushnet book, or Robert Kluger's book, or so forth, Richard Kluger's book, you go in the back, and you would realize that these must have been parallel universes, because there was no mention of the cases, even though I believe that the record shows that Brown was decided before the case, and then they held it back for several weeks because they wanted the school term to end. And so they let the school term end, and then they announced it. And every Monday when the cases were announced, people would come to see if Brown had been decided, because it had drawn worldwide attention. Now, when they announced it, it sort of disappeared. There was one newspaper story, a little byline on it, and he was retried with a jury that had 2 Mexican-American women on it. Of course, he was reconvicted. And so people say, Michael, why do you make such a big deal of this particular case? And I said, well, because it's the first application of equal protection. Post-Brown, although it was written at the same time as Brown and technically announced in the book, there's Brown in the 54 Reporter, then there's Hernandez. They're actual literal bookends to each other. And because it was the very first, if you read the case, it mentions the bathroom, it mentions the signage. It reads like an anthropological study of Edna, Texas. And the anti-subordination language in there is actually better in many respects than Brown, which, as you all know, required yet another Brown 2, a year later, for implementation. And of course, the wink and the nod being given to the white judiciary at the time was that it should be implemented with all due speed, with all deliberate speed. And so it never was fully implemented, most scholars today feel. But Hernandez immediately began to desegregate juries in the state of Texas. And it makes you wonder how they could have ever convened a jury in El Paso or San Antonio, 2 towns that both have today over 60% Mexican Americans. How they could have done so in Brownsville. It turns out in some of these small towns in the valley, they had, just because there weren't enough Anglos to go around, they had in fact seated Mexican Americans, but given the criminal justice, for the most part, either the complainant or the defendant was Mexican American, and so they felt this was sort of a separate kind of court presided over even by some Mexican American judges. At the time, you didn't have to be a lawyer in order to be a judge. At the time also, there were fewer than 24 Mexican-American lawyers in the entire state, and I think that therein lies part of the tale here. James Onda later in interviews said that he had been allowed to go to the University of Texas A&M and then University of Texas, and graduated in 1950, the sweat year, by the way, just for the record, because they thought he was Italian. And he said, I never corrected the record. But after he became a lawyer, he was offered a job in the legal department in the city of Houston, and they gave him an application, and they said, Jimmy, fill it out and start work on Monday. And he looked at it and he says, I knew that I wasn't Italian anymore. Now, he had never actually averred that he was Italian. This was sort of a personal joke. He was light-skinned, even though both his parents were from Mexico. But it said, white, Oriental in the language of its time, Negro, and then Latin American. And even though he wasn't Latin American, and he was born in the United States, and so he said I knew what they meant. And so I checked Latin America and the job disappeared. That's how he ended up 2 weeks later working for Johnny Odetta with the only job offer available to him. Normally a graduate of Texas A&M and UT would have had their lives virtually assured. There were 2 of only 4 law schools at the time, not sort of 3.5 law schools given the sweat school. And it was a difficult time for him, and he took this case because he wanted to learn how to be a trial attorney, and he certainly learned so. Gus Garcia and Carlos Cadena had tried only one case before. It was a case called Gala versus Bastrop, and if you follow desegregation, this is one of the few cases, along with Mendez, a Ninth Circuit decision, where Mexican-Americans plaintiffs actually won the case. But in Gala versus Bastrop, a little town, in fact, the town mostly burned 2 or 3 weeks ago. It's near Austin. Proof that there's a God, I suppose. It finally burned. I'm sure 50 years later that's just accidental. But the school district lost the case, but they decided not to appeal to the Fifth Circuit because at the time, the Fifth Circuit extended all the way to Florida. That was the entire South. And they didn't want a case going to the circuit that Mexicans had struck down a segregated school system. So Bastrop was a little integrated oasis in the middle of all of Texas. But they had tried this case, but the 4 of them never tried a case together again. This was simply a quotidian case that came in over the transom, for which they were never paid, for which they had to raise money to take it to the Supreme Court, and where they won. Now this is an extraordinary series of facts. After all, even in those days, it took some real oomph to get a case in front of the Supreme Court. And if you read the decision, it's only a 7-page decision. I've been trying to get more criminal law and criminal procedure teachers to include it because, as I say, it not only speaks to the subordination of Mexican Americans, but it reads like these were observers. They read into the record the schooling and the restaurant lack of accommodations, the fact that these 4 men couldn't stay at the hotel, the one hotel in town every night because there was no public accommodations law, so they would drive in 2 hours each way from Houston and San Antonio. And the arc of these men's life is extraordinary as well. James Lee Onda, as I say, goes on to become a very successful trial attorney and is named by President Carter to the bench and becomes the 2nd Mexican-American federal judge in history. And not until he has founded MALDEF, the Mexican-American Legal Defense Fund, what is now Texas Rural Legal Assistance, and had left his mark desegregating Corpus Christi and other towns during that period of time. Gus Garcia, 10 years, almost to the day, in June of 1964, after springing Pete Hernandez on parole and getting him released because he had a bad leg, he was no threat, and because he just advocated for him. Gus was found dead on a park bench in San Antonio 3 hours after he had died. He had essentially drunk himself to death. I have letters that I've included in the materials that are very sad to read. He'd been disbarred, essentially had mental illness that today would have been treated, and of course he medicated himself. But the other 3 men had trajectories that were extraordinary and useful, and all of them provided this opportunity, this rare opportunity of such courage and extraordinary lawyering. Not one of them was a member of the Supreme Court bar. They all had to be sponsored, and it was harder than you might think to find white attorneys to sponsor them. In fact, they sort of engaged in some subterfuge to get admitted to the Supreme Court bar. They raised what was then an equivalent, in those days, an $800 filing fee by having tamale sales and the like. They all 4 stayed in the same room when they went to the Mayflower to argue the case. I always stay in the Mayflower as a result, just in sheer homage to their work. And as I say, James Onda lived to be 82, and he asked me about a case. I serve on the MALDEF board, and he said, "How about that redistricting case? Did we win it?" And I said, well, in fact, we did. And he took great pride. It was the very first case argued by Latinos on both sides. Nina Perales from Aldef wins, overturning District 25, a district that had been gerrymandered to remove a Mexican. And on the other side, the state Solicitor General in Texas, Teodoro Cruz, argued for the state and won the Dallas seat. So they actually split the decision, and both of them had argued a case the very first time. Now, for a number of years, after we had the conference and after I wrote the book, and it was published and of course available in fine bookstores everywhere, I got a call from a movie producer who decided to make a PBS show out of it, which appeared 2 years later. It's called A Class Apart, that actually has this record and is built in, is available from pbs.org. You can drop me a note and I'll send you a URL that has it online. And since that time, I've done additional research, and it's been brought to my attention that there actually was a Mexican-American who had argued a case the year before. James Lee Onda went to his grave thinking he was the first. It turns out he was not. There was another lawyer from California who had argued a commercial case. It wasn't a civil rights case, and so I still think it's correct to say that these four were the first four lawyers ever to argue, Mexican-American lawyers to argue a civil rights case. And it turns out, that notwithstanding what I've said about Latinos being on both sides, that there were some Puerto Rican cases, some insular cases, where Puerto Ricans were on both sides of those arguments. I think those are fairly specialized kind of pleadings, but it does show, of course, is that this is a fluid record, one that needs to continue to be analyzed. I just don't know how to go about examining every single case in the U.S. Supreme Court prior to 1954 when this was argued. But I will say this, he didn't live long enough to see Justice Sotomayor installed on the Supreme Court. But he said it was just a matter of time. He thought it would be Nina Perales, who's the daughter of Cesar Perales, who founded the Puerto Rican Legal Defense Fund. So we actually had a Puerto Rican arguing on the Mexican-American Legal Defense Fund side, and Teodoro Cruz, a Cuban, defending the state of Texas. Ironic at sort of every sub-ethnic level on this particular case. There have, of course, been Mexican-American men and women who've argued cases since that time, including other MOLDEF wins, including Plyler versus Doe, the case of undocumented school children, and other voting rights cases and redistricting cases. But I think that there are some important lessons here, particularly for those students who might be listening. One is that you have to take every single event that comes to you seriously and do your very best on it, because that's what your clients expect. There essentially was no equal protection doctrine for Mexicans prior to this case. They created it by arguing, by doing the research, by doing the kind of anthropological work that was required to show that this was what was called a sundown town. A sundown town in Texas meant that, in the South generally, but in Texas meant blacks and Mexicans shouldn't be caught here after sundown. And that's what Edna clearly was, so clearly was. It also shows that lawyering requires extraordinary courage. When I go into court today, I'm not afraid that someone's not going to let me stay in the room. They're glad to have my business today. These men couldn't even stay in the room at the hotel, and in fact, Gus Garcia, in order to shame them, set up a little bar, a little table, and drank out in their parking lot. Now, this, of course, coincides with his terrible drinking habit, shall we say, but he did that to disrespect the people who wouldn't let him stay there. There is one thing in the movie where I think for some dramatic effect, they suggest that Gus was drunk the night before. In the morning, he argued the Supreme Court case. There's no record of this, I have to say, and the evidence given by the filmmakers was they heard it in the course of making the film. And Judge Lee Onda was there and told me once that while they had actually kept a person whose job it was to stay on him the whole time, sort of like staying on a fast tight end. You signed one guy and you don't leave him, and he didn't. And I think that it fits too easily with the tropes of Mexicans being drunk. But in any event, that adds some dramatic flair to this. I've always thought this was a movie that deserved more cinematic treatment, although I urge you to look at A Class Apart, because I think that it also has its own, even though you know how it turns out, it has its own dynamics and is really quite a good movie, very useful movie. Finally, I think that the true lesson here is that we have to fight and struggle in order to prevail. We can't merely endure, we must prevail. And the only way that we do that is, frankly, by undertaking sometimes difficult and unpopular tasks. Whenever I attend a MOLDEF meeting, we have picketers who are picketing our supporters. When I spoke in Nebraska recently, I received a threat from someone who said, "What is it about illegal you don't understand, Mexican?" And I was going there as the designated piñata. I was going there to argue that we ought to have a different kind of immigration status. And of course, as you know, Nebraska's overrun by Mexicans. I think there must be 6 there. But they were all cited, and of course, that put them at some apprehension. But the discourse that we have today is a dangerous discourse, and this is the point I want to end on. The New York Times has run stories talking about illegals, using the term anchor baby, as if children born in the United States to undocumented parents connived somehow to arrange to be born in the United States so that 21 years hence they might be able to, in the DNA chain sure to come, will name their parents to be permanent residents and then 10 years later to become citizens. Clever little bastards that they are, and yet our discourse has led to such a situation that thugs in Long Island, white thugs, will go what they call beaner hunting. And so they mistake Marcelo Lucero from Ecuador, who's a permanent resident with permission to live in the United States like any one of us, to be an undocumented Mexican, and they kill him in a crime brought as a hate crime. Now, I don't wish to suggest this is isolated, because in fact it's not. There is rampant violence for people who simply look Mexican in places where Mexicans aren't expected to be. So the crimes of driving while Mexican, walking while Mexican, conducting business while Mexican, working while Mexican continue, even with people who are long-standing citizens. It happened in the state of New Mexico, with my home state, where 3 Mexican-American students were standing outside a fence to school, not drinking, not doing drugs, simply standing there after school hours, but within a half hour of school hours being over, and they were all arrested. And when the police were asked why in a deposition that we took, he said, well, 2 of them wouldn't answer us when we asked them where they were from, and the other one spoke with an accent. With an accent. Let me just say, that's half my family. That's half of New Mexico. The state of New Mexico is 50% Mexican. Of course we're going to speak with accents. Have you ever been in Texas? Have you heard Governor Perry speak? That's an accent. The New York Times style manual says they must use the term illegal immigrant because the term undocumented is a euphemism. I would argue the opposite, that today illegal has become a euphemism, a term of hate, applied in the noun form, so that we have illegals. Not only people who, of course, can't be illegal, but who are characterized by adjectives as illegal, turning into nouns, people who are illegals. This discourse has consequences. Someday, turn on Fox News and listen, and you'll be mortified at the language being casually used. Governor Perry, who I disagree with on virtually everything he's done, signed, as you know, a law allowing undocumented college students to establish, with 3 years residence, their ability to receive in-state tuition. He's being beaten up by people from Massachusetts and other states, even though Senator Orrin Hatch introduced the original DREAM Act in 2001. This is a parallel universe that I don't even recognize. One that is so hate-filled, one that is so anti-immigrant, one that is so nativist, one that is so restrictionist, that we now, in Alabama, a case where there can't be more than 10 Mexicans. And I'm talking about people who are white who've eaten in Mexican restaurants. There can't be that many Mexicans in Alabama, necessitating the restrictionist law where they now want to count school children, a complete violation of Plyer versus Doe. And make no mistake, we will win that case, just like we're winning cases in other states. But it's good. But we had to close our Atlanta office to move attorneys full-time to Arizona because we couldn't afford to do both. At a time when the stock market's down, where we're perceived as the troublemakers and demonized as the people who harbor terrorists and aren't American, it's difficult to raise money for these events. And so the struggle does go on. And Judge Leonda's last words to me were, "We done pretty good, Michael. We done pretty good." Well, he did pretty good. And I think Hernandez and the record to this, you should read and weep at your own leisure, because the fact that we could have sixth graders kicked out of school because they spoke Spanish. We had no schools for Mexicans past the 6th grade. As a result, of course, we had fewer college attendees and graduates and lawyers. These took their toll. And then when World War II intervened, we had a disproportionate number of Mexican Americans who gave their lives and were injured in World War II, served in the infantry, to come back to find out they couldn't buy houses with the GI Bill, and in some cases weren't even allowed into the restaurants. The case of Macario Garcia is one I've done research on. Macario Garcia was injured twice in World War II, and came back after receiving the Congressional Medal of Honor from President Truman. Only on Monday and on Friday night he was not allowed service while he was dressed in uniform at the Oasis restaurant outside Houston. The scene of Aniceto Sanchez 5 years later. This scene becomes transmogrified in the public imagination by Edna Ferber, who writes it into her novel Giant. I have found the connection here. She spent time with a Mexican-American physician who figures prominently in the movie. Of course, the Mexican's played by that all-purpose Mexican Sal Mineo. Sal Mineo. When he wasn't playing Cochise and others, he was playing the Mexican in that movie. And you recall the very last scene in the movie where Rock Hudson, he isn't happy about his son, Dennis Hopper, marrying the Mexican woman, but he goes along with it because they produce this beautiful child. And he goes into this restaurant and gets beaten up by the white proprietor. And Elizabeth Taylor flashes those eyes and says, "I've never been more proud of you." And in the final scene, the black and white, the Mexican and white child playing with each other. And everybody has said that was an unusual moment in cinematic history because Mexicans were depicted as a positive force, or the discrimination against them was singled out. That's true. But if you today just try and think of a movie where a Mexican's not a droguero, where a Mexican's not a maid, etc., we're still at the very early stages of full incorporation of Mexican Americans who total over 40 million persons and who constitute 2/3 of the school children in the state of Texas and 40% of the school children in California. And these are children who were here making their way through the pipeline. We will have to deal with these communities. We will have to, at some point, have comprehensive immigration reform. And then I can rest, and others in my generation can rest, such as Judge Lee Onda rested, that we done good. Until that day, we haven't done good. I want to thank you very much for your attention and for your letting me tell you about this particular story. If you teach criminal law, or criminal procedure, I urge you to consider this. If you don't, by all means, take a look at the movie A Class Apart and start paying attention to the way that this particular discourse on immigration is being played out in the elections. It's going to be a nasty turn, you can just tell, and so we're having to prepare for that. But in the meantime, all of us rely upon the inherent goodwill of our fellow members of the community, and at some point, I'm confident that in my life that there will not be a need for an organization such as MALDEF, which too often today gets called in because we are the cavalry. There's just simply no one else to do this. When we finally get an elected member in Victoria, Texas, which is the biggest town near Edna, they finally, Mexican Americans elected to the city council, only after single-member districts are litigated by us. Turns out now to introduce anything, you have to have a second. You have to have a second. Maybe that's good government. Hard to believe that it all of a sudden became good government when you have one Mexican on the school board or in the city council. So we will continue the struggle. We will continue to lawyer aggressively. And I will tell you that we have fewer Mexican-American students today in law school than we did in 1982, the year I graduated. We have more Latino students because they've come from all over the world, and I think that's a good development. But Mexican-Americans are 66% of our population, and there's actually fewer, not just as a percentage, but actually fewer, several hundred fewer than there were then. I think we have a long way to go before we rest, and while we don't have sundown towns anymore, we have seconds in Victoria necessary to introduce legislation. So we have a long way to go before any of us can rest. On the other hand, we've made spectacular progress. The truth is we have more elected officials in Texas and California than we ever had. We even have Mexican governors in New Mexico. It's true she's a Republican, and it's true she's originally from Texas. My dad kidded me that I married a Texan, and therefore I was in a mixed marriage. It's going to take a long time for these attitudes to break down. Let me just tell you, my grandfather used to say, Michael, ten cuidado con los tejanos, porque son todos desgraciados y no tienen vergüenza. What he meant was Texans are desgraciados, so it translates this out, and they have no shame. And what he meant was, when his train was going in World War I to Fort Hays, Kansas, he ran across a restaurant in Amarillo that had a sign, no Mexicanos ni perros. And these men, half of them died on the fields of battle defending us, and he returned to a country that wouldn't admit him of full citizenship. These are in the brainstem, the collective memory of every Mexican American, and every Latino for that matter. And I think until we confront and address and remedy this history, that we will still have beaner hunting in Long Island. We'll still have the Marcelo Luceros, completely innocent and here legally, being killed because people misapprehend who they are. And they don't just grow up with this hate. This hate is instilled in them and cultivated in them and encouraged in them, I would argue, by the media. I think until these are dealt with, and until they're dealt with increasingly in the South, you may think that this isn't an issue that comes here, but why are all these restrictionist laws being passed in the South, in Georgia and Alabama? It's because they're fearful of Mexicans, and I think that this is a tax that is being cast upon Mexicans. Let me just say that, and this is the last thing I'll say before I take questions, I don't believe in open borders. Open borders would allow Abba and Abba music to come into the United States. And I just can't believe that that's a good thing. I can't believe that's a good thing. And so I'm not for open borders as long as there is Abba music out there that might somehow slip over the border disguised as European music or something like that. Thank you all for your attention. I appreciate it very much. You're very courteous. I'd be glad to answer any questions people might have, except about Abba, who were inducted into the Rock and Roll Hall of Fame last year. There is no God. Yeah. Yes, Beverly.
You've been talking about people who became activists in practice in the 50s. And I know you're very involved now, so I'm wondering if you could tell us how people are becoming, how they're creating activist practices now. I'm just thinking of the many things that are interested in that.
Well, Judge Lee Onda became a lawyer in 1950, but the other three did this in the 1940s, so they went back even further than the 1950s. I think that there are many ways to do this. First, you simply have to do well at whatever you do. Your clients deserve no less. And I think a lot of students sort of think that Supreme Court cases are all Thurgood Marshall, trying to desegregate, and so you pick out test cases. Sometimes your clients simply come to you and they're bringing chickens and they need your help and you're the only one that can help them. So I think that's an important object lesson. So all of us, you might have to say no, but the second part of that is here's someone who might be able to help you, and that's, believe me, how we get most of our MALDEF cases and our clinical cases. We took a case out of our University of Houston clinic this last year that we won 9-0 at the U.S. Supreme Court, overturning an immigration deportation matter with a guy who had a single Xanax in his pocket. One Xanax. Hell, half the court personnel had more than that, I think. You can win these cases, but you have to try them, and you have to be prepared to try them, and you have to be prepared to get the resources to try them. That's what makes the difference today with the cases, the organized resources. The purpose of organizations, bringing religious accommodation cases in particular, are a good example of this. They pick this circuit and that circuit, and they did it the way that Thurgood Marshall did. That is, you carefully lawyer, you get the best lawyers, you know you're going to lose some on the way there, but your reach exceeds your grasp, but you finally get it. And no one said we could win that case, the voting rights case. I mean, it was a real crapshoot. It cost us over $1 million, but we do it because we have to do it. And so I would say this is something that falls not just on Latino lawyers. It falls on all lawyers who have a conscience. I think that all lawyers ought to be involved in pre-law activities. They ought to be speaking to school children. They ought to be using their own lives as exemplars. They ought to be involved in scholarship funds. In my ALS column that'll appear in the next newsletter, I call upon every law professor to give at least one activity of this kind of pro bono activity every semester, which would generate enormous resources, because there are, believe it or not, people who don't even do that. And I understand who's going to give me, it's never going to help my reputation that I was all Saturday helping some kids take practice LSATs last week. This is hard slog work like these guys had. 400 cases. They had no idea this would go to the U.S. Supreme Court. So you have to do your best. You have to be your most creative. You have to be willing to tilt against the windmills. You have to today it's easier with the collaborations that are possible. I know that if I can't take a case, someone else can, and I can almost always refer someone to. So you have to be in those kinds of networks and cultivate them. You have to be in the professional associations. The reason that Judge Lee Onda didn't know that someone had litigated a case is because there was no Mexican-American bar in those days. I mean, there just wasn't. They didn't know each other. It wasn't in the papers, et cetera. And so today we know each other, the world is shrinking, et cetera. But it's also harder today because the other side is just as well organized with a lot more money and in some respects, inertia and public policy on their side, certainly public discourse on their side. So, but you have to you can't give up. I mean, this is, I think, what came from my being in a seminary is, honestly, I was taught to look at things over the long haul. And maybe I can't solve everything. I'm sure I can't solve most of them, but I can help train people. These were my students. Two of these students who took this case to the Supreme Court were my students. They learned about how to litigate this from me. I never learned that from a Mexican-American lawyer. All my learning came from other folks, and I loved all my teachers. I took my learning where I got it, but we now have 225 Latino law professors. We have people writing books. We have Republicans serving as governors. We've either come a long way or have a long way to go. I'm not sure what that is. But the truth is that the opportunity is ours to seize it, and we have to do so. And we have to do so even when other people don't want to give that up. And so that's the only way I can live, really. Yes?
I want to continue that thought a little bit and talk about the lost aspect of Hernandez. So, like a lot of people who come to your book or come to the case, you're kind of surprised to see how significant it was. You sort of realize what happened in the kind of wave or shadow of Brown. And given that things have changed as much as they have, perhaps not enough, that Hernandez doesn't get more play, particularly in light of your book. I mean, is it not a squib in any of the common law books? I mean, put aside, criminal law or civil procedure, to me, it's kind of core common law, and that is left to the side. Why do you think that is? Why hasn't there been more groundswell?
Yeah, I think that there actually is both a racial answer, which all of you are going to expect from me, and a non-racial answer. Who came on the Ed Sullivan show the night that the Beatles played? Who was on just before him? The guy, Frank Gorshin, the guy that played the Riddler. He was on, he did a little routine. This is actually a Billy Crystal movie, It got swamped in the greater glare that was Brown because of the interest convergence, because that was an internationally appropriate case, because it was retried, because you had innocentes, you had these little children who, through no fault of their own, just like the undocumented children, did no wrong. And you have a Norman Rockwell picture of the little girl from New Orleans with tomatoes being thrown at her. And Pete Hernandez was not a Norman Rockwell poster. So it was a tough case. But that's the way criminal law happens. And plus he did it. This wasn't a case of innocence projects, before their time. That makes it all the harder, to tell you the truth. And because he was so unpopular, many of the organizations didn't get behind him. They thought, well, civil rights, housing, and other things are really more important to us, and we aren't getting our fair share there. And we have more military now in Korea, and we really have to do better, and so forth. So I think part of the answer is the sort of the racial anonymity. People think of Mexicans as largely a Southwest phenomenon. Let me just say they don't think that in Long Island anymore. And now that we're a national population, people have to think of us, but we're characterized in ways that are seen as either hide your daughters, the greasy Mexican Lothario, or drug dealers or maids or other things that people fear. And even though they want to hire us, after all, and the reason our families come here, they don't want to deal with the consequences. And maybe these children didn't do wrong, but if we deport the parents, they'll take those children back with them where they belong. I've heard this time and time again from serious people who say, and by the way, Michael, I really love you. You don't even speak with an accent. Well, yeah, when I'm speaking English, I don't, and I speak with a perfect Spanish accent. It's not you, it's your kind problem, and so I think that this is a very serious problem that has serious consequences, but I'm also willing to let the process take its place. But then the other side doesn't get to sue us every time something happens. There are aggrieved whites suing because of the Top 10 Texas plan, a plan I helped write. Even though it's a deracinated plan, it's the top 10% in any high school in the state, and they're suing us because they said this is a racial surrogate. Well, no. What was a racial surrogate was the admissions practice beforehand that led to Hopwood, that led to this. So they'll sue us if we have affirmative action. Look at Fisher, the case just in the Fifth Circuit, and they'll sue us if we don't, because then it's a surrogate. I mean, we can't win for losing. And I lose on either end of those discussions. And so some of it is simply lack of public awareness. Some of it, I remember one time I was a finalist for the deanship of a, shall we say, a southern state with a Confederate capital, okay? And they kept saying, do you think you'd be comfortable here? And I said, well, I voted it. I kept, I didn't see the memo. So I thought they meant, well, you're not from the South. I said, well, I live in the South. I voted at Stonewall Jackson Junior High this morning, or yesterday. And they said, well, we don't have any Mexicans here. And I was flabbergasted. And I'm thinking to myself, this is one of those things where they must be testing you just to see how you're going to react to a really stupid question. Because as dean, you have to, you know. And I said, well, first of all, that's not true, because two of them made my bed this morning. I got excellent service, let me just say, and I tipped well. But I said, you think I didn't know that? I didn't come here to be dean of the Mexicans. If I wanted to be dean of the Mexicans, I'd stay in Houston. Well, we're 28% of the population. I got a real shot at being dean of the Mexicans there, or back in my home state of New Mexico. By the way, the last study of Harris County juries, where we're 28% of the population, showed that 3% of all jurors called in Houston, in Harris County, were Mexican. 3%! In a district where we're 28%. I mean, this is as bad as it was 51 years earlier. It's true they don't cut us out now, and immigration matters now in a way it didn't. By the way, Peter Hernandez was a citizen. It's morphed into a completely different form. And when people say, well, Mexicans were white, that was never done to, just for the record, that was never done, in case my sarcasm hasn't penetrated, that was never done to advantage Mexicans. How do we not be on a jury with 6,000 members called in a district where we should be one of each jury? That was done to exclude us. You know, they knew where we were when they were building Mexican schools and not educating us past 6th grade. They somehow sniffed us out. You know, we could run, but we can't hide. And people say, well, there's intermarriage. You know, well, all groups intermarry. That's not it. The one-drop rule was used to disadvantage blacks, just as this rule is being used to disadvantage Mexicans. And so I just constantly try and turn it back so people truly understand that we didn't just arrive. My people came to this damn country in 1695. How long ago do I have to have been here before I get accorded full citizenship? My grandfather used to say, because New Mexico was a territory until 1912, because most of the state was Mexican and they didn't want Spanish speaking, which is in our Constitution, he said, I didn't cross the border crossed me. Juan Bautista de Olivas came in 1695 in the second de Vargas expedition. How can I be a newly arrived person? You know, I mean, honest to God. We're here. We're not going anywhere. That's part of the problem with us stealing Mexico fair and square years ago when we created a war and went there and took it. You know, that's the way we got Panama, and that's the way we got Mexico. And so here we are, Mexicans, and we're staying here, and we're moving, and we're intermarrying, and we're moving to Long Island, and we're getting elected, and we got governors. Don't yet have a Supreme Court justice. We've got a Puerto Rican, and as you know, that's the same. Yeah. Thank you all very much. I appreciate it. Understand there's a reception out here? Yes.